Yes, ma'am.
Okay, thanks and welcome back to the Internet Openness and the Law Roundtable. We are about to begin our second discussion of today's roundtable. We're going to focus on how to construct open Internet rules. We're looking for rules that are legally sustainable and also rules that achieve the Commission's goals of protecting and promoting Internet openness. I think we can dive right in, but first I just wanted to echo a comment that John made at the beginning of today's session. This is a legal roundtable, so we're addressing these topics from a legal perspective. But our audience is not just lawyers. It includes all people with a stake in the rules. Indeed, we're fortunate enough to have Commissioner Boyle here from Nebraska, a non-lawyer, but who has tremendous experience and insight in communications regulations. So as with this morning, I'm going to begin today's discussion with some opening questions for our panelists. They'll each have 3 minutes to respond with opening remarks, and we'll then consider a series of questions that we've prepared and incorporate other questions that we receive from the public, emails, tweets, questions from the chairman or other commissioners. With that, I'd like to begin by introducing the panelists and asking the opening questions. Fred Campbell, I want to begin with you. Fred is the director of the Center for Boundless Innovation and Technology and a former chief of the FCC's Wireless Bureau. Fred, your comments talk about what the Commission can and cannot regulate as common carriage. Can you discuss how the Commission has handled this issue over time, and what, if any, discretion you believe the Commission has in determining whether a carrier should be regulated as a common carrier?
So I guess the one area where I disagree quite strongly with the earlier panel is the notion that the FCC's authority to reclassify under Title II doesn't entail a lot of risk. At least I disagree with some of the panelists. The definition of telecommunications service was what was addressed in a Supreme Court case, Brand X, and for the non-lawyers out there that sort of led us to the path where we are today. The Supreme Court in that case never addressed the definition of telecommunications, which is part of a telecommunications service, and that definition is ensconced in the Communications Act. And the history suggests, and the terms of that definition suggest that it does not, that broadband Internet access doesn't fit the definition of telecommunications. It's an issue that the FCC has never addressed in detail. It addressed it once and in order that was overturned in court on other grounds. It sort of got lost in this large triennial review unbundling proceedings. And I think that's a real risk, that if the court were to address this definition of telecommunications, there's a very good chance that the FCC would lose on reclassification, because that definition more properly applies to traditional telephony service. In the dial-up era, which was still dominant when the Act was written, there was actually a phone call that was made. And that part of the service was regulated, and the Internet backbone, which didn't have phone calls, was not. So there's that. Section 706, I think the FCC is on solid ground legally to the extent they have a set of factors and do a case-by-case, similar to what was proposed in their Notice of Proposed Rulemaking. It's similar to what the D.C. Circuit upheld in respect to automatic roaming and broadband. And I think that were the FCC to adopt that approach, it would probably succeed in court. The question then is, how far could it go? I've got about 45 seconds, but they can adopt rules under 706 so long as they don't constitute per se common carriage. I think in order to avoid that, they could have some either rebuttable or irrebuttable presumptions, so long as there were also areas in which there could be negotiation between the parties. So one example that's been discussed on the record and in the press is, maybe you could ban prioritization generally through some sort of presumption, but allow user-directed prioritization, or allow user-directed prioritization subject to some factors in a complaint process. I think you can go about that far with 706 and have a sustainable protections for the open internet.
Thanks, Fred. And there was a lot in there, and I'm sure we'll have a chance to discuss a lot of those pieces as we go on, but I want to stay with common carriage for a minute. And Tejas, I want to turn to you. Tejas is a research fellow at the Columbia Law School, and he's also a former colleague of ours in the Office of General Counsel. I want you, if you could, to talk for a minute about the concept of common carriage per se in the D.C. Circuit's recent decisions, and in particular, if the Commission chose not to rely on Title II, but took a 706 approach that had this limitation with regard to common carriage, how could the Commission construct rules for no blocking or discrimination within that common carriage limitation?
Sure. So first, let me just begin by saying thank you very much to the Commission for inviting me back, and especially thank you to John and Stephanie for having me today. I'm very happy to be here. So to your question about what the D.C. Circuit meant in Verizon when it was referring to common carriage per se, my reading of the case, and I think it's certainly open to interpretation, the case is not exactly a model of clarity, but it's the combination of the no blocking rule and a rule that prohibits all unreasonable discrimination, which in the order was taken to mean almost all forms of discrimination that were not reasonable network management. Those two together, I think the D.C. Circuit understood to impose what was practically a zero price rule, which constituted price regulation, which was then common carriage regulation. So that is my understanding and reading of the Verizon court decision. So what that means is that if the Commission chooses not to exercise Title II authority and wants to proceed under Section 706, it can't couple a no blocking rule with an absolute prohibition on discrimination. So you might imagine some forms of rules that allow some forms of discrimination and target other forms of discrimination that might meet that standard. So one thing that I've talked about is focusing in particular on vertical discrimination. So this is where platform provider, practically the network facilities provider, favors its own affiliated applications at the expense of competing applications. So that might be a sustainable rule under 706, that the no blocking prohibition lives and the presumption against discrimination only applies to vertically affiliated discrimination. Now, I'm going to turn briefly to Title II because I think one thing that's important to emphasize is that this is a theory under 706 and it's an untested theory. So it's not necessarily clear that the D.C. Circuit would agree that even this falls within the FCC's authority under Section 706. I think it is clear that at least that much, which is not even network neutrality as we understand it, at least that much would fall within the FCC's authority under Title II. And I think it's also clear that the FCC could probably do what we really consider to be network neutrality under Title II.
Thank you. Marvin, I want to turn to you. Marvin Ammori is a fellow at the New America Foundation. And Marvin, you've argued on behalf of smaller edge providers like Kickstarter and Etsy for a flat ban on paid prioritization. Can you talk about why that's so important for those entities and also the source of the Commission's legal authority that you would look to support that policy?
Sure. So what these smaller companies have put in the record and what they've argued for, including Kickstarter's one lawyer when she testified here, is a very straightforward, bright-line rule that can be easily administered even by lawyers who don't spend most of their day thinking about telecom. So if you think of paid prioritization, you sort of have two components to it. One is a ban on access fees, sort of in the 2010 order, no fees to reach users, no fees for prioritization. And so if you're trying to litigate a case involving a ban on access fees, you can just say, is Comcast demanding an access fee of me, yes or no? It's a pretty easy, bright-line rule. On the discrimination side of the paid prioritization rule, right, a rule against application-specific discrimination is pretty bright line. You bring in an engineer, and they can determine if some applications are being treated differently than others in a way that's disadvantageous, and it's pretty much a straight up and down bright line test. The proposal in the order at the moment in the NPRM is far vaguer. Commercial reasonableness, there's permissible discrimination, it's the rule, not the exception, and they have to hire probably expert witnesses to debate questions of harm to consumers, harms to competition, harms to free expression. So that is, the opposite of certainty versus the bright line test they want. And, if you look at the record evidence, I pulled some of the quotes because I thought they were pretty good. You have companies like Reddit, Sidecar, Netflix, the largest companies in the country in the ad hoc telecommunications committee, which include credit card issuers and automakers, PadMapper. Their quote is, "The only way to protect small companies like us is to enact bright line rules against abuse." Right? Even the Internet Association, really large companies, say the use of 706 by itself provides certain challenges in trying to establish a readily enforceable bright line rule that ensures consumers are adequately protected. And you look at, Tumblr, Imager, all of them come to this same point, that they really need bright line rules. And this is probably why, most of the startups that I've seen, probably 60 of them in the docket, have so strongly supported Title II. You can't ban paid prioritization under 706, full stop, I think, after the Verizon decision. Right? The Verizon decision reviewed the 2010 order, which had either a ban or a presumption, sort of hard to tell what it was, against paid prioritization, and the court said that would leave zero room, for negotiation and differentiation, whereas, as I read it, the common carrier prohibition would require the FCC to leave substantial room for differentiation in terms and discrimination. So you can't do a ban on paid prioritization under 706. I don't think you can do a presumption against paid prioritization under 706, both because the Selco decision emphasized the lack of a presumption in the data roaming order, and because whatever the 2010 order had, it kind of was like a presumption. This might be stronger. So I think you really have to do Title II to do bright line rules.
Thank you. Julia Johnson is here. She's the chair of the Minority Media and Telecommunications Council. She's also the former chair of the Florida Public Service Commission. Julia, you've heard what Marvin had to say and others. MMTC has taken a different view of the impact that Title II and a ban on paid prioritization would have on innovation, deployment, and most importantly, consumers. Can you talk about your view and why you prefer a different approach?
Certainly. So MMTC was actually excited about the Verizon versus FCC decision because one of the things we seem to do is focus on what the decision did not provide. But for us, MMTC, we believe that the decision provided teeth and regulatory authority for the FCC to act in areas where it had not acted in the past. If you look to the decision, and I'll do as Marvin did, if you look to page 643 of the court's decision, the court concluded that the FCC had the power to regulate broadband providers' economic relationship with edge providers if, in fact, the nature of those relationships influences the rate and the extent to which broadband providers developed and expanded their services for end users. From MMTC's perspective, that's a big win. That's a big win, and that's the kind of authority that we want to see the FCC effectuate and act upon. For us, the Verizon case set forth a roadmap, a very clear roadmap for regulation under 706 in a way that would provide both flexibility in terms of prioritization and also an area that would allow for the bridging of the digital divide, that would allow for entrepreneurs to have opportunity to negotiate deals. But let me walk through how we get there. The FCC provided a roadmap on how to modify its rules so that those rules do not unlawfully impose common carrier requirements on information services. The path that they set forward was grounded in the Selco case. The Selco case held that while the FCC's commercially reasonable requirements bore some marks of common carriage, it did not impose common carrier obligations and was therefore lawful. The court went on to say that there was a gray area in which, although a given regulation might be applied to common carriers, the obligations imposed were not common carrier per se. The Verizon court cited to the Selco case and emphasized that unlike a common carrier regulation, the data roaming rule leaves room for individual bargaining and differentiated terms, which seems to be key to avoiding common carrier pro se designation. Now, I know there are groups on the other side that would say that's a problem if you can't do an outright ban. But for us, when we look at sponsored data plans, we see the fact that the FCC can come forward with a presumption against paid prioritization as a way to protect consumers against harm and also empower consumers that would like to see flexible data plans, and also provide protection for edge providers that a carrier cannot come in with its own proprietary content without the heavy hand of the FCC. I know I'm out of time, but I'll continue as you.
John Windhausen is here today on behalf of library and higher education organizations led by the American Library Association and EDUCAUSE, also the president of Telepoly Consulting. John, your clients have supported Title II, but you also have suggested in your comments that the Commission could adopt a different kind of rule, a rule of Internet reasonableness, which employs several rebuttable presumptions that are tailored to the protection of the open Internet. What are those presumptions, and how would this Internet reasonableness rule work?
Sure. Thank you, Stephanie. And I'll get to that after just making a quick opening comment. First, since I know you're interested in the record, I do want the record to reflect that Chairman Wheeler and Commissioner O'Reilly are still here present in the room, and it's a testament to you both. Even though you're off camera, you are listening intently to everything that's going on in this proceeding. So I really thank you, and I think the public deserves to know that. So I'm here, as you mentioned, Stephanie, for higher education and library groups. This is an incredibly important proceeding for libraries and higher education, and I think my one concern about this entire proceeding, even though the NPRM was wonderful, these debates have been wonderful, there hasn't been enough attention given to the needs of education and libraries and higher education and their interests in supporting an open Internet. There's an incredible amount of use of cloud-based services, multimedia teaching, digital archives. There are online universities that depend upon an open Internet. So that's why this is so critically important for education. And just as an example, as I mentioned, ALA and EDUCAUSE are the two clients, but when we drafted our comments, we ended up with a whole laundry list of other library and higher education organizations signing on to these comments. Another 10 organizations supported this role in this proceeding. So it's an incredibly important issue for all of us. The issue for us in terms of the legal issues, we see Title II and Section 706 both as viable alternatives. I'm going to spend most of my thoughts on the Section 706 because you're right, we don't agree with the commercially reasonable standard. That in our view, is a non-starter, and I think Nuala O'Connor began to articulate that commercially reasonable could be interpreted as just allowing the two commercial parties to enter a contract, and then that defines what might be commercially reasonable for them is not reasonable for the general public interest. So that's why we said we've got to come up with a different, better standard. And our whole theory is what this is all about is protecting the Internet, right? We want to preserve. We think the Internet is great today. We want to preserve that culture and character of the Internet. That's why we articulated this Internet reasonable standard. And we think that could include some presumptions, which I'm not going to have time to go into all right now, but there are different kinds of presumptions. There are conclusive presumptions. There are rebuttable presumptions. We think those can play a role. I think you can have bright line rules under a 706 Internet reasonable standard. And I think the whole theory here, our view, is that the Internet works because you pay an entrance fee. And the theory of the Internet is you pay your entrance fee. Once you get on, you can go anywhere. You can go to any application. You can go to any website. You can use it both as an edge provider and a consumer, and often they're merged. Entities are both producing content and consuming content on the Internet. If we can do what we can to preserve that theory of the Internet, this is not just a legal issue. It's important to get the law right, but this is, frankly, for the commissioners I'm looking at in particular, this is for the public interest. You need to be able to explain what it is that you've done, what the standard is. And I think there's a lot of merit to an Internet reasonable standard, and defining that can really make it easier to explain to the general public.
Thanks, John. And I want to, last but certainly not least, turn to Commissioner Boyle. Commissioner Ann Boyle was elected to the Nebraska Public Service Commission in 1996, and she also serves on NARUC's Telecommunications and Consumer Affairs committees. And you've had a long and successful career as a state regulator. From that perspective, what are your views about how we can best construct rules to ensure that an open internet benefits all American consumers?
First, is this on?
Yes.
Thank you. Thank you first for inviting me to be here. And Chairman Wheeler, like you, I am not a lawyer, but I really appreciate your willingness to sit down for 24 hours of listening to all of us. And Commissioner O'Reilly, I don't think I've met you. However, I do read your comments. I'm going to come from a different perspective. And since I'm not a lawyer, I was hesitant to come here because of all the legal language that we would have to interpret and say, and know it has to be precise. I am a consumer advocate who has been with NARUC for 18 years. I was elected in 1996, and that is a year that we all remember as the passage of the Telecommunications Act, where the world changed. And in my terms at working with the National Association of Regulatory Utility Commissioners, I discovered some of the problems that were obvious. That because there was no regulation, and as a matter of fact, one person who represented a carrier came up to me, a wireless carrier, and said, because I had made a list of 25 different things that they needed to address in order to be fair to the public. And among them were early termination fee contracts and mapping and other things like that. And later we went on to number portability, which all of us know today they have occurred. But I was told at the time, you can't do this. You don't regulate us. And my response, and so you understand what I'm like, I said, any time that any business takes advantage of the people who use their services after paying them with their hard-earned after-taxes wages, and they take it, and the industries they take an advantage, government will step in, and I am government. And just so you know, I am a fourth-generation politician. My great-grandfather was in the legislature in Nebraska in the 1890s. So I grew up in that environment, and I grew up in an environment of having my father and grandfather also being elected office holders, and so learning the hard way when my father would say, do the right thing regardless of what anybody thinks about you. And so that's what I have had to live by. I am very concerned because there was a reference made to the millions of people who sent in information, and it was as if it was done only by the public, I guess, the people who care about the public. We often forget, I think, that the public is paying all the bills one way or another. And therefore, they need to have a voice. And if they get hundreds and thousands of people who want to write into the FCC because somebody may have told them to do this, I don't think it's a problem. You know why? Because when you look around this room, we are seeing people who are from all sides of government. We see people who are representing all the industries, but we're hardly seeing any person who just sits out there at home wondering how he's going to make ends meet, and also how are they going to, why are things so difficult for them? Well, when we have a country that wants to go to spend millions and billions of dollars in lawsuits, instead of sitting down and working with one another like they should, I think it's a disaster, and the public doesn't even know how they are being treated. So in Nebraska, there's a guy called Larry the Cable Guy. In leadership, you can get this done if you open your minds. But Larry the Cable Guy's mantra is, get her done. And I would say that to the lawyers in this room, who it's become a pretty lucrative income to go to lawsuits and paralyze the process. And bottom line is this: every time the lawsuits are filed, it is a way to stop things going forward, and as long as we stop doing that, the carriers get to do what they want, and the public suffers from it. So I don't understand why, especially lawyers, I know that they have to represent their clients, but when we are working in a country where everybody is affected, and frankly everybody is affected today, with internet usage, it's probably very few people who don't use an internet. I think that we have a responsibility, and we have to have the leadership in this country to come together. These are not partisan issues. They need to be taken out of partisanship, and I work with 4 Republicans, all men. I'm the first woman ever elected to the Nebraska Commission in its 100-year history, and we get along well. Because why? They're all Republicans. I'm the only Democrat. However, we don't fight about party. We discuss things, and sometimes we disagree, but we always disagree friendly, and we don't go to court over anything, and we don't turn the backs on others. So it is important that Congress and the carriers and the FCC work together and try to solve these problems. Some of them are going to continue because technology is always going to change as we know it. And I understand that. But to stop and say perhaps, oh no, we don't want to have anything in the books that says that it's not, you have to be non-discriminatory. Really? Are you saying so be discriminatory? I don't think that's fair. And yes.
Excuse me, I thank you for all those comments, and we'll have lots of time to discuss this in depth. And one of the things that you mentioned was how you have, the kind of discussion and debate that you have with your colleagues, and that's exactly what we hope for on the panel today. And you'll have more time to reflect on what your experience has taught you. But I want to move on to some of the other questions because we have such a short time and a lot to get through.
I apologize, Stephanie.
Not at all.
That clock was still going for me.
Oh, no worries. So I wanted to, in the panel this morning, there was a considerable amount of discussion about bright line rules and case-by-case approaches. And I want to turn to that here where we're talking about how we construct the legal rules. Because there are different ways of doing it, right? We could adopt broader legal standards and then provide additional guidance through adjudications on a case-by-case basis. Or we could, at the outset, adopt brighter line rules that provide more detail initially. There's, I think it's fair to say, some trade-offs there, and I wanted to begin the discussion by talking about those trade-offs. And Marvin, I know you are on one side of this debate, and I thought you could start it off.
Oh, sure. So, the question of sort of adjudication versus rulemaking, there's a vast literature in the law about rules versus standards. Right? We want to implement a rule that's sort of concrete and takes a little more resources to implement the right rule up front, but then is cheaper and more certain to implement over time? Or do we want a sort of vague standard, and then as cases come up, you adjudicate and you articulate what the rule will be that way? And there are strengths and weaknesses to both, but this, I think, is a textbook example of when you would want a bright line rule according to the literature. So you'd want a bright line rule when you'd want to make sure there's certainty in the market, right? And so everyone in the country is influenced by the open internet rule, right? Every business today is an internet business, right? When you look at even, people who sell wares on Etsy to even, Ford Motor Company, everyone relies on the internet to sell and for their inputs. And so it impacts everyone, small and big, commercial, non-commercial, libraries, you name it. So you want certainty for all of them. There's really a high cost of implementing a case-by-case approach over the years. You really need almost full-blown trials, expert witnesses, versus a bright line rule similar to the one that I explained, no fees, no application-specific discrimination. And then in a case-by-case approach, you're definitely benefiting those who have far more resources. So in the record evidence, there's actually Sidecar, whose general counsel is a former FCC commissioner, Rochelle Chong, writes that they only have one lawyer who does lots of different things, and she couldn't field a team to take on the carriers at the FCC. So your case-by-case approach with a vague standard really benefits those with the most money and the deepest pockets. And a standard is usually beneficial when you don't really know what the right answer is, when you sort of want to see how the market will shake out. But the kinds of rules that we're asking for provide a lot of flexibility, right? The ban on access fees doesn't provide a lot of flexibility because we know the right answer, right? We know that the 2010 order gave 4 reasons why a ban on access fees made sense. One was if you have access fees, you encourage carriers to degrade the baseline service in order to extract fees and paid prioritization. And it also would shift and change the existing workable, successful internet that has not had access fees. And then on application-specific discrimination, there's a lot of flexibility for network management even within that. So I think the rule we can adopt will be targeted.
Thanks. I don't know if anyone else wants to weigh in. And in particular, one of the issues in the internet context, and we heard about this in the first panel as well, is that it is a dynamic environment, that there's a lot of change that we've already seen and that we expect to see in the future, right? And I'm wondering if in the context of such dynamism that we cannot predict, whether there are any concerns about bright line rules and how that would affect innovation. I don't know if, Fred, you wanted to respond.
Yeah, I'll chime in on that. In respect to the Internet of Things, for example, it is a new world. That's where I would disagree with my colleague, Mr. Ammori over here, that in that kind of dynamic market, I think it does make sense to allow some flexibility because I don't think we know what the right answer is in every case. And currently, we sort of have treated the Internet in many cases as if every player is the same. And I don't think the evidence reveals that. So, for example, who has the most power? The 2010 Internet order applied equally to the smallest wireless Internet service provider as it did to the largest Internet service provider in the country. And then companies who are operating on the edge, such as Google, Netflix, and the like, Apple, are some of the largest countries in the entire world and operate on a global basis. So to say bright line rules are appropriate because there's a power imbalance and we know what those bright line rules should be seems to me to put the cart before the horse. This is a very immature market still. Online video, for example, is still developing. It's not clear at all what is going to happen there, and the Commission is apparently considering some of those issues right now. Should video be treated exactly the same as something else? I think those are all open questions. So I think the bright line approach does foreclose flexibility, and I'll try to use one specific example. So big data, the whole concept, edge companies, and by the way, I'm not going to comment on the substance of it. I'm trying to keep legal and not policy-based, but they are doing many things that would probably be illegal under Section 222 of the Act, and there are all of the arguments out there that that's a good thing. My question would be, why is it a bad thing for carriers to do it? Now, I'm sure people can make distinctions and the like, but to be clear, that 222 was put in place long before the Internet of Things was even conceived. So do we want to say we already know how that should work, or should we think more broadly about how the different players in the Internet ecosystem relate to one another? And a more flexible approach gives the agency an opportunity to do that.
I think another question about bright line versus case by case is its effect on broadband deployment, which is, after all, one of the central tenets of Section 706 and a foundation of the 2010 rules and certainly the NPRM. Julia, I don't know if you have thought about this in this way, but your MMTC's comments really talk about how to get broadband to deployed to all Americans. And I wonder if you could comment on that.
Certainly. I'll go back to the question and say that I agree with Fred on his answer with respect to adjudication versus case-by-case basis. The adjudicatory process reminds me of when I was a regulator, and that was a long time ago. And we were dealing with utility-style regulation. And in that context, there was certainty but no flexibility. But it was also at a time when the technology was not changing as rapidly, and that the regulators themselves served as the body to kind of spur the change. In this instance, we have a very dynamic market, a dynamic market that is basically driven by change and innovation. So we believe that the best opportunities for new service, quality of services, better price services will allow for that case-by-case approach that will allow the companies to innovate as between companies, innovate for edge companies, and innovations that will benefit consumers.
So let's talk for a minute about some of the particularized practices and approaches. Marvin, we've been talking about paid prioritization. So if I understood your opening comments, you focused in terms of paid prioritization on the presence of access fees, as you described them, and application-specific discrimination. I think it would be useful to have a conversation of what we mean by paid prioritization, right? The term that's also often associated with this is fast lanes. Because if we can define what it is we're talking about, we may have a better sense of the best adjudicative or regulatory tools to use to deal with this. So Marvin, since you've offered us a definition already, let me start with this. Many people think of paid prioritization as a technical action. In other words, a last mile network advantages for the performance of certain transmission over others. You've added to that an economic notion, that there was a fee being charged. Do the two of them have to both be present to be paid prioritization, or is it one or the other as you consider it?
Well, so I believe both, whatever we call paid prioritization, fast lanes or not. Yep. And I reviewed the order. Actually, Judge Silberman refers to fast lanes in the concurrence as something required under 706. So whatever we call them, I think there's harms to access fees and harms to discrimination. And so let's say you're in a situation without any fees, but a situation like, say, the Comcast BitTorrent case or other examples where a provider disadvantages some sort of class of applications or some applications, maybe a payments application or a video application or voice telephony. Those are harmful, right? They choose winners and losers on the internet. They make some applications sort of get a better service than others in a way that harms the way innovation would happen and harms user choice. On the other side, access fees, both just for reaching consumers, right? Access fees over the network have never been part of the internet, or for prioritization, those are also harmful because they raise the cost of innovation for startups. They hurt non-commercial and startups more than anyone, and when it comes to the kinds of paid prioritization that's out there, combining those two, fees plus prioritization in terms of technical prioritization, even some of potentially the interconnection gimmicks that have been going on, increased bandwidth versus other applications, increased exemptions from bandwidth caps. All of those are ways to discriminate in favor of some applications over others that I think would change fundamentally the way the internet has worked and undermine all the dynamism we've seen. We've seen that dynamism because we've had a general purpose network, as the FCC has recognized, that anyone could use and create new applications on top of. That's, I think, why we've had all this dynamism.
So I just want to break it into a couple of pieces for the sake of people who are following, right? You've gone through what you've basically given us is an inventory of ways in which you think the last mile network can advantage or disadvantage edge providers, right? Mm-hmm. Content providers, Hulu, Amazon, Google, anybody like that. You've given us technical advantages that could be given to some. You've given us economic charges on the edge provider. You've referred to the terms and conditions that a consumer would use to get access at home when you talked about data caps. Okay. Is it your view? Correct. In other words, as I took it, you were saying, well, there could be exemptions from data caps, and they could have the impact that you described. Under your paid prioritization rule, would all those be absolutely illegal? Are you applying a bright line rule to all of those practices?
Yeah, I think a bright line rule to all of those practices makes sense. I haven't seen, when you look at sort of the data over the years, and even from these roundtables, there hasn't really been a strong argument that I've seen that capacity doesn't solve the problem of quality of service. In the few moments where an over-provisioned network could require quality of service, Barbara von Schievek has laid out this sort of user priority, sort of detailed test. But over and over you see the argument that capacity alone solves the problem, so you don't need prioritization if they just keep investing in the network. As for access fees, I think there are lots of problems with permitting, essentially terminating monopolies to start charging for termination, right? And the FCC has moved away from that when it comes to bill and keep and other areas where they've realized that letting terminating monopolies charge for access is a real problem. And you don't want to get into the problem of over-cost charges for termination that you then have to price regulate. Historically, we've had a price of zero, and that has worked well.
So let me ask other people to come into this. Let me introduce another concept if anybody wants to address it. As Marvin rightly says, different people have made different proposals. You've referenced one. AT&T has made its own proposal for what it says would be a flat ban on prioritization under 706, in which it introduces the notion, it says, of a user-directed exemption, as it were, from that. Anybody have views on the use of bright lines in this respect, in the kind of way that Marvin has described it? John.
Yes, thanks, John. So a little bit of a difference in degree perspective compared to Marvin's comments. I do think that there are some bright line rules that are probably worthwhile, but they should probably be limited. So just in looking at presumptions, so as I mentioned in my opening comments, there are conclusive presumptions where you just decide those are off the table. And so the example I would put forward is if there was intentional blocking or intentional degradation. Perhaps the Madison River case is the prime example. That's something that is just very clearly should be forbidden. And that might, you want to just say that's conclusively, presumptively illegal. Under our proposed Internet reasonable standard, then, however, most of the activities should probably fall into the rebuttable presumption category, because conclusive presumptions are fairly rare in the law. Most, and given the vibrancy of the marketplace, you probably want to send some signals to the market that these are things that we're going to look with disfavor on, but still allow the ISP to have their day in court, if you will, to come in and say, even though paid prioritization, we're going to be presumed to be illegal, but we're also going to give the ISP an opportunity to overcome that. It should be a high burden of proof they have to manage in order to be able to make the case, but it should be presumed and strongly presumed to be illegal unless there's some very strong public interest countervailing reference. So I think there is an important need to send signals to the marketplace. So the idea of just leaving everything to a total case-by-case determination, I think runs the risk of really sending no signals whatsoever. You haven't preserved an open Internet then if it's totally case-by-case. So I think it is important to establish some things that are bright-line rules or conclusive presumptions in the most extreme cases. I think a lot of other conduct should be subject to a rebuttable presumption with a high burden of proof. And then in each case, you will still have some case-by-case adjudication that has to occur to then further flesh out and define the rules, and that gives you the ability to be flexible and adapt to the changes in technology. But you have to have some standards. Otherwise, you really haven't protected an open Internet.
Okay. Fred, Julia, is that all right?
Well, yeah, and I'll be short. On one of the points that John raised, from MMTC's perspective, perhaps there should be a test that would look not just as paid prioritization as bad, but let's look to see if the companies could come forward and meet a burden of consumer benefit so that they have the incentive to innovate and bring forth pricing models that they would have to bring forth to the regulator. And a blanket ban says everything's bad. So for a low-income person that might like sponsored data plans, we want to better understand how can we get there under a ban? How can we get there in the way under Title II that would have a ban on those kind of pricing mechanisms? So we would say, at least from that vantage point, there should be a very, very, very strong presumption against it, but there should be an incentive to come forward with plans that demonstrate consumer benefits.
Okay. Fred?
I think what I would add to that, to be clear, I think I agree with Professor Hurwitz that two-sided markets are extraordinarily complicated, and therefore, my personal opinion, I wouldn't favor bright-line rules. But in the spirit of trying to figure out what's legally sustainable, when you look at the Verizon case, they looked heavily, the court looked heavily at two Supreme Court cases that addressed what it meant to impose common carrier regulation in the cable context prior to cable being covered by the statute. And that's and I have to look at my notes, Midwest 2 and Southwestern Cable. And in one case, the the Supreme Court said a regulation that prohibiting a certain activity in certain circumstances was okay and didn't run afoul of the common carriage. It wasn't per se common carriage is how the Verizon court would phrase it. And in the other, I think it was Midwest 2 was the problematic case. In that case, the cable systems were required to hold out dedicated channels, first come, non-discriminatory basis, with no limitations whatsoever, and the Supreme Court said that goes too far, and that's per se common carriage. So just very simply, just looking at those two cases, I think under 706, and I'm basically concurring with John and Julius' position, that it would seem likely that the court would sustain a rule that has some, prohibitions in it, and whether they have to be rebuttable or irrebuttable. I didn't come prepared with specifics on each question for you, but I think they would, similar to the Southwestern case, if it could be justified pretty clearly and the like, say that's fine, as long as there's also the opportunity for some negotiation. And you're going to the filing by AT&T, and there was a discussion, by one of the panelists about this, who was pro-net neutrality, about is user-directed prioritization fine, for example. And it seems difficult to say that if the goal is to protect consumers, user-directed prioritization, if a user wants prioritization, that should be disallowed. And I think that's an opportunity to have some room for negotiation that would meet the kind of the Southwestern test versus the Midwest 2 test, if that's what the Commission would like to do. Commercially reasonable versus reasonable under the Act, I've taken the position that, I'm not sure what the distinction really is at the end of the day. As long as the FCC's rules fall into the, quote, gray area, unquote, sort of defined by Southwestern and the Verizon court, the Verizon court did say the FCC will get Chevron deference on that. And so you'll get some deference on that term.
Right, just for people who are following this, with the scorecard, the gray area refers to Judge Tatel's opinion where he says there are some practices that are common carriage per se, but there's a gray area where something may look like common carriage, but it may be okay because it also looks like something that isn't common carriage. That's Fred's reference. John, I want to come back. I know you wanted to respond to this, but I want to add something about the commercially reasonable test. You've made the point that your internet reasonableness test provides a clearer explanation, and that's important, right? Because as the chairman has said, we're looking for the best approach that can be offered, and that's why the comment period is so valuable. I do want to know one thing that I think the NPRM emphasizes, or that is true in the law. As it's proposed by the Commission, I don't think the commercially reasonable test applies only to the judgment made by two commercial parties. In other words, the commercially reasonable test arises from the data roaming case, just to go back in time, where a test was constructed precisely because the goal of the Commission was to incent the use of, in that case, mobile, but broadband services generally. So I don't want to leave people with the impression that the Commission necessarily believed in the NPRM, that it was defining the commercially reasonable test narrowly. But that said, you've made the point that you think your articulation of the test is necessary so people understand what the Commission actually means. And that may go into your discussion of this topic.
Yes, that's perfect, John. Thank you for clarifying. So our internet reasonable approach is really, we feel that that's founded on the bedrock of the existing internet, right? So what we want to do is preserve the existing culture and character of the internet as an open platform, not just for innovation. We support the virtuous circle of innovation, but we'd say it's also the virtuous circle of education and learning. And that gives us something to ground our internet policy, our open internet policy on, whereas a commercially reasonable standard, I realize, yes, the way the FCC defined it, it had 14 different factors, but unfortunately, as you try to work through all of those factors, it becomes very difficult to ascertain, well, where is the Commission going with this? Because you're looking at so many factors at once. An internet reasonable standard gives you a chance to look at the current internet and say, hey, this works. This is what we want to preserve, and craft a standard that's built around that. And that entrance fee model that I articulated earlier, you pay to get on. It's not free, so there's a commercial transaction. But once you're on, it should be unlimited. That is the model that gives me trouble, that causes me to have trouble with the AT&T proposal. So back to Fred's point about we're protecting consumers, yes, but a user-directed prioritization exemption causes me great concern. For two reasons. One is that it sets up the dynamic where the ISP is now making decisions or is involved in manipulating traffic. That's not the way the Internet is supposed to work. An Internet reasonable standard is meant for the ISP to be neutral, right? They carry the traffic back and forth. They are not involved in prioritizing anything. So it breaks that barrier and then starts to involve the ISP in manipulating traffic in a way that I think could set a bad precedent. The second reason I'm concerned about a user-directed prioritization is that it changes the incentives of the ISP now to promote scarcity. You know, the more they limit the capacity, the more people are going to want to pay to get enhanced delivery. It's much better to not to give them that incentive and for them to have the incentive to build more capacity for everybody. As Marvin said earlier, that is ultimately the direction that we want our Internet access to go, to build more capacity, not less. So those are two reasons why I think the AT&T proposal is not a good idea.
So I want to, we've talked about 706. Fred talked about it as a basis for the use of either presumptions or flat bands. I want to come, Marvin, to you with a question about the precedent under Title II. In the previous panel, people noted that Congressman Waxman had recently sent a letter to the Commission, and in it he discusses the precedent under Title II. He says there are some examples that the FCC has found practices inherently unjust or unreasonable where conduct should be prohibited under Title II. He says that generally has involved blocking of content. He then goes on, however, and says that the FCC has interpreted Title II as allowing differentiated services and prices so long as like services are offered to similarly situated customers under reasonable terms and conditions. In other words, Title II, if I understand him, allowed for differentiation of service and simply required that customers who are in the same position have access to those services. He goes on and says, some of these Title II precedents resemble the paid prioritization arrangements that advocates of Internet openness want to prohibit. How do you read the history of Title II vis-a-vis a suggestion that an absolute ban could be placed on certain kinds of conduct, both technical and economic, as you've described it?
So I'll answer that, but I also want to get to presumption since I only really talked about rules and standards. So as I read Title II, if we're trying to get at the harm of access fees and discrimination among applications, I think you could look at access fees and say that's an unreasonable practice. The access fees in one part of the 2010 order were treated as analogous to blocking. And if you look at the Salco decision and the Verizon decision, one of the things that they consider per se common carriage is the fact that Midwest Video was required to carry some channels for free, educational channels. So if per se common carriage involves carrying something for free, then it would stand to reason that free carriage is possible under common carriage rules, under Title II. The FCC in Verizon, the court also found that if there were a ban that everyone had to pay zero on carriage, that would also be no room for discrimination at all, therefore it's a common carrier rule. So there are two different pieces in the cases we're talking about that suggest a zero price rule is a common carrier rule. And there's been lots of, and if you look at the word unreasonable, I think the argument is that because the word is unreasonable, there must be a case-by-case approach or there must be some flexibility. You can define whole classes of conduct as, quote, unreasonable. You see it in other areas of law, and you see it here too. Other areas of law, right, unreasonable restraints on trade could be like per se, certain kinds of agreements. Unreasonable searches under the Fourth Amendment can be, per se without a warrant going into a house. So there are per se unreasonable actions. And, there are tons in the history of Title II around confusing charges, blocking of calls, contracts with utility pole agreements that don't have recourse to filing complaints at the FCC. And on discrimination itself, I do think Carterphone is a great precedent, right? Carterphone is essentially, interconnection with consumer premises equipment without discrimination, and you can discriminate against other people's modems or your own. You could put a hamburger phone would connect, Part 68 rules. There's no discrimination, no fees. I think Carterphone is the perfect example, and I find it also kind of confusing that AT&T and others have glommed onto this argument, which feels self-serving, that Title II, which they're arguing so strongly against, doesn't ban paid prioritization. I think it strongly does under all those precedents. Let me talk briefly about presumptions, if I may. I sort of looked into presumptions as a result of this hearing, and the quotes about presumptions are that they're the slipperiest of legal concepts. You have mandatory presumptions, and they might shift the burden of production or the burden of proof. And I just think it adds a lot of uncertainty. What you have already is a sort of, I guess, a prima facie case of discrimination or unreasonableness, and then that would shift the presumption. I guess it would be presumed to harm consumers. Then they would try to rebut it, and then they'd get another chance to do reasonable network management on top of that. It's sort of 3 steps, and you're injecting through the back door a lot of uncertainty and giving the advantage to the companies with the biggest armies of lawyers simply through that presumption. That would take away the benefit of a bright line ban. And if for no other reason, the fact that Gus Hurwitz embraced presumptions makes me really concerned.
Is that application agnostic reasoning?
No. It's in light of everything else that he said. But I do think that even if you want to do a presumption, you can't do it under 706. I think the Celco discussion and the Verizon discussion make it pretty clear that you can't even do a presumption under 706.
So let me just ask about that. Then I'm going to ask a question. If anybody here wants to be in favor of a hybrid approach, this question is for them, so I'm just giving people notice. If not, I'll answer. But it's interesting, Marvin, one of the examples you give of the history of an absolute ban is a ban against unreasonable restraints of trade. And yet, in the data roaming order, which was this 16-factor test, there was one absolute prohibition. It was an absolute prohibition against unreasonable restraints of trade. And that order was upheld as not being common carriage, which makes one believe that it would also survive under 706 review. In other words, there are some people who have come to us and said that example of unreasonable restraints of trade precisely demonstrates that certain kinds of practices could be banned under 706. I don't know if anybody...
Simply respond. I mean, the rule under...
I want to also give other people... Yeah.
But it's sort of a question to replying to my question. Yeah. But so long as that per se ban on action doesn't require them to hold themselves out and serve all at a sort of regulated price of 0, then sure. But that's exactly what net neutrality is designed to do.
So anybody else want to talk about this issue of 706 and presumptions, and bans? Otherwise, I'm going to go to a question from the audience.
Well, so when I said, I think the FCC would get quite a bit of deference under commercially reasonable. The FCC has often distinguished itself, and this has been upheld, from a DOJ or FTC style antitrust analysis by saying that it can do something more and that it has other public interest concerns. Well, so if you want to distinguish between reasonable and commercially reasonable, what is commercially reasonable? I don't know that there's any case law out there that says it is the same thing as antitrust, but going to your point, Jonathan, it would seem reasonable to think it's not commercially reasonable to engage in anti-competitive activity that would violate the antitrust laws. So to your point, I do think, given the roaming case and that factor, that the FCC could be upheld in saying that commercially reasonable prohibits anti-competitive behavior that would violate the antitrust laws. Now, I don't want to get into what the substance of that would be. And I realize that the kind of per se rules under antitrust is its own term of art and the like, so I'm not trying to go there. It's not the same statute. But by analogy, I think you'd probably be on relatively good ground legally with an approach along those lines. The issue becomes, as far as the absolute ban across the board that some are seeking, is that, antitrust authority, I think, is relatively clear that these things aren't always harmful, and that's the risk or the downside of going with an approach that leaves no flexibility, as you may be leaving some consumer good on the table.
Just adding to that.
Yeah.
One of the interesting things about the Verizon case is that when they cite to the Cellco decision and talk about flexibility and differentiated services, and in their analysis of common carrier per se, they cite to the Cablevision versus FCC decision, right? Mm-hmm. And that was a decision that had a presumption in it, as if to suggest, at least for MMTC, is that one of the ways that you get away from common carrier per se would be to have this prioritization. If you look at the case of Cablevision versus FCC, the court endorsed a rebuttable presumption that exclusive contracts between cable operators and regional sports networks were unfair and harmed MVPDs. And so stepping back from that, certainly you could have common carrier obligations per se that could be problematic. But the way that you can get around it's not carte blanche, is to say, but we have this rebuttable presumption. And the Verizon case clearly cites that case as one of those opportunities to provide a tool in the regulatory toolbox.
Okay. So, Tejas, let me ask a question. It comes from the audience, and it refers to the paper that you and Tim Wu authored together, the sender-side paper that we discussed in the first panel. Here's the question. Under Tim Wu's approach, I'm sure this means and your approach, and Mozilla's approach, what happens if the affected edge provider doesn't file a complaint, but users do? Wouldn't that leave users less protected because the rules for users, parens, based on Section 706 parens, have to be significantly weaker?
Sure. So I'll come to that question. I just want to quickly pick up on one of the points about importing antitrust standards into the regulation here and some of the effects. So I think that that's something that has been thrown about quite a bit, and this has also come up, in the context of whether or not the FTC should also concurrently exercise jurisdiction over open internet and network neutrality regulation. And one of the things that I just want to make sure is clear and is emphasized is that the communications regulations have never been coterminous with antitrust regulation, and that has been purposeful because there are particular harms in the communication space that I think that sit outside the antitrust standards, and that is particularly true when it comes to forms of vertical competition harms, where vertical competition harms have really in the past 10, 15 years not been actionable under antitrust laws, but they've continued to be a mainstay of communications regulation, and that's because of particular features of communications, the particular market power of the platform and facilities providers, and the possibility of network effects and strong entrenchment in the application layer. And so I think it's easy to say that we should turn to antitrust for standards that apply here, but I don't think it's correct. And that's just one thing that I wanted to say.
Sure.
But turning to the question about the sender-side proposal, I don't think that the Commission has to only act in response to a complaint by either the edge provider or by the consumer. And so if a consumer brings a problem regarding the relationship between the ISP and an edge provider to the attention of the Commission can act under its own authority to examine that, and again, under the full strength of Title II and whatever classification the Commission uses to classify that particular commercial relationship. And so the fact that the complaint originates from a consumer is of little consequence in that context, I think.
In fact, I think the NPRM that the Commission issued had as a tentative conclusion that one means of enforcement would be what it calls self-initiated investigations.
Right.
Okay. Stephanie?
So I want to turn I'm going to turn to no blocking, but before I do, I just have one quick question, and this is about zero rating, and this is the practice, Marvin, that you mentioned, where particular applications or services are excluded from an otherwise applicable data cap. It's also a form of sponsored data, which, Julia, you mentioned. And I was thinking about this in advance of today's event, and I I checked out Wikipedia Zero. So Wikipedia Zero is right now, at least as of last night, in 29 countries, working with 34 operators, reaching 350 million people, giving them free access to Wikipedia. There's no payment involved between the carrier and Wikipedia. And in their principles, they specifically lay out that it's a non-exclusive arrangement. So I guess my question is, when we talk about what kinds of prioritization are harmful, this is still an application-specific arrangement. Are the same harms attendant to this kind of arrangement? So I guess that's back to you, Marvin, since you raised it initially.
So I think Wikipedia Zero, which is limited to the global south in places where people make $1 a day, right? I mean, 1 billion people live on less than $1 a day. 2 billion people live on less than $2 a day. You have very little infrastructure. In places like that, it might make sense. And to be frank, Wikipedia on a feature phone uses very little data. Essentially, it's a marketing benefit for the carriers in a competitive market to try to differentiate themselves. It's not really a huge benefit to, say, Wikipedia or the app providers. And it doesn't have the same harm of extracting rents from Wikipedia, Spotify, whoever else. And so I think that's a very different circumstance from the United States where, the carriers have really healthy profit margins. They don't actually need more revenue from Wikipedia that couldn't even afford to pay in order to be able to expand to low-income places. They have, Internet Essentials, they have Universal Service Funds, they have lots of different ways to reach more and more users without tinkering with the open platform of innovation by biasing some applications over others. Because let's say that some applications start paying AT&T for sponsored data. That gives AT&T an incentive to keep the data cap low because they now have a new revenue line of charging applications in order to be part of the exemption. And within a few weeks or near the end of any month, you have an incentive to use, say, Pandora over Spotify or whatever. So I think it'd be problematic in the U.S., and I haven't seen much justification for it. And just a point on mobile, since there's been a lot of discussion about mobile network management and aggressive network management. I litigated the Comcast case. I've spent way too long working on net neutrality, and I hope we get it right this time. But that time, the cable companies were engaged in application-specific discrimination against 5 peer-to-peer protocols. And what they said was, we have a shared network, just like the mobile guys, and we need to engage in application-specific discrimination or else the whole network will fall apart. And the FCC said, no, move to an application-agnostic discrimination method, gave them a grace period, and Comcast was magically able to do it, and they're really happy with their new practices. And I think that the mobile carriers will probably be able to figure it out as well. I'm suspect of some of their arguments around application-specific discrimination that they don't seem to even do yet.
I wanted to address, because I want to kind of go back to, because another argument that Marvin made about wireless, that he made in general, he suggested there's really no justification for any kind of prioritization or discrimination and the like because there's no congestion on the networks. And at the same time, many say there's also no reason to treat wireless and wireline differently. And I would say beyond the issue of network management, wireless is never really been future-proofed. The argument that once you lay the fiber to the home and then your marginal, costs, et cetera, everyone added, and all the traditional wireline arguments don't really apply. The commission's found that there's a spectrum shortage, and of course, that's interrelated with how many more, your site density, but site density costs additional funds. It's not the same thing as laying down your fiber and enjoying a low marginal cost forever. So there are economic differences beyond, and very real differences beyond just maybe network management. For example, could you enter into some sort of agreement that allowed wireless providers to increase their density to support a particular service? I can imagine that being a pro-consumer option. Secondly, I would say also the fact that Marvin sort of admitted that Wikipedia model could be pro-consumer, but it's different overseas. To me, that gets to the issue of how much do we really think we know about this market today? Ideally, you adopt rules with principles that are flexible enough to accommodate things in the future. And, maybe Marvin's right that particular example would do us no good, although I did think we had people here who are low income. But, and I don't even really say it facetiously. I mean, I'm not sure I agree with him, but overall. But we don't exactly know what kind of services might be useful here. And so I'm, again, making the point about I just think the, absolute bans are potentially harmful to consumers.
I'd like to add to that. I think Fred hit it on the top there. Marvin, when you talked about there are other programs out there. You talked about Internet Essentials. You talked about, I think, named other couple programs for low-income people. But I would suggest for the regulator, what's the harm in having a rebuttable presumption where you can look to determine if there are consumer benefits? Because we've named at least one wonderful program where there were benefits to low-income individuals. So what's the harm in having a rebuttable presumption when it can be determined that there are consumer benefits, particularly if those benefits are for low-income individuals? That is at the center of MMTC's argument. We want to make sure, yes, that there are only fast lanes. And we believe that 706 will provide the opportunity for the FCC to guard against and ensure a level of service that will satisfy all Americans. But at the same time, having the ability to have differentiated pricing could work. I'm not saying it does, nor is the FCC. But the way that the rule is written, it says a rebuttable presumption. And in that vein, at least MMTC sees no harm in having that sort of a test.
Maybe one sentence, one broad point. I mean, the carriers always make the argument that if we're allowed to charge Google and Facebook and whoever else, we'll take that money and then subsidize low-income providers. I doubt they'll do that. They're making money hand over fist. They have high margins. If they wanted to really serve more consumers at a lower margin, they could do that now. And the arguments around zero rating are the same ones they've made around paid prioritization for a decade.
All right, I want to go to a question.
Could I ask one question, though?
Yes, Ann, go ahead.
I saw, because of all this discussion, all this time, what's wrong with transparency? That's part of one of the three bright lines. And what is wrong with anti-blocking, saying you shouldn't block, you can't? And what is wrong with anti-discrimination and costs? It's been really beaten up, but at the same time, because we represent, people who are in public office or who are appointed, we represent the entire country of everything. And if we have to go into having hearings or people, the general public cannot do that, and the innovators of the small businesses cannot do that. They can't afford it. And so what happens is they go out of business because they can't afford it. It's all costly. And so I don't understand. Are we saying it's okay to discriminate? Is it okay to block people here based on whoever's decision is made by somebody? It's just not right, and it just flies in the face of fairness to the entire country.
I think we've heard a range of views on the discrimination point about how we could address those kind of concerns, and on no blocking, which is where I want to turn. There's actually, I think, an interplay between the rules, both no blocking and transparency. We received a question from the public. This is from Greg in California. Greg says, consumers pay for a particular speed, say 12 megabits per second or 50 megabits per second, and these are the standards by which the consumer should be connected to all the internet. And the question is, if I'm paying 12 megabits per second for a 12 megabits per second connection to the internet, why should I not receive that speed when connecting to sites such as Netflix or others? Tejas, I know you wrote a bit about how the transparency rule and the promises that ISPs make in terms of selling their services might interplay with some of our other rules. Could you address that?
Sure. So in the Verizon decision, I think the court draws a distinction between a no-blocking rule that ensures access to ISP subscribers generally, and a no blocking rule that requires access to an ISP subscribers at a prescribed minimum speed. And it seemed to indicate, although again not clear, that the latter was likely illegal or outside the agency's authority, and the former possibly legal. But then that drives to the heart of Greg's question, or
Yes.
Gary? Greg's question. So Greg's paying 12 megabits per second, but the rule can only offer access to a subscriber generally. And so the question is how you give effect to both of those. And I think what the Commission might consider doing is requiring that ISPs honor both commitments. So they honor the commitment to an edge provider to provide access to the subscribers generally, and that the ISP honor its commitment to the subscriber that presumably the advertised service is for 12 megabits per second. And so whatever content it is that the consumer wishes to receive ought to come at whatever rate is predominantly advertised. Now that invites some gaming, right? It invites it invites ISPs to possibly say up to 25 megabits per second, but 12 is the standard, except where some edge providers have paid, or you can imagine all sorts of interesting looking advertisements. And so I think there'll be some work that you have to do to the transparency rule to make sure that there's some predominantly advertised speed, and that sets the baseline for the relationship between the consumer and the ISP, and that avoids some of these sort of gaming problems. But there's definitely a way to do it, to combine a general no blocking provision with the promises that the ISP makes to its consumers.
John, you've also proposed an approach to the no blocking rule in your comments. Can you talk a bit about that?
Yeah, sure. So I know that the Verizon court had some dicta around no blocking and suggested the idea of a broader definition of serving consumers generally, but with a minimum quality of service, so sort of minimum standards. As we looked at that, in other words, suggesting that the FCC could require a minimum level of service, that comes pretty close to a duty to serve. That comes pretty close when we looked at that to imposing a common carrier-like obligation. And so as our schools and libraries and higher education looked at that, we were a little nervous about identifying that particular minimum level of service. Also, that's very hard to define when you compare a small library in a rural area to a major university. They're going to have very different minimum levels of service that they're going to require. So the exercise of trying to define a minimum level of service for which there's no blocking seemed to be difficult practically, seemed to be difficult legally. So we proposed a different alternative, which is to say that the ISP cannot block the consumer's choice of which website or application that they choose to go to. So that is not a duty to serve. That is simply once the ISP chooses voluntarily to serve a consumer, then they must carry with that the additional obligation to carry out the will of the consumer. And I should also make sure to point out, I don't think this is in the record until now, that a no blocking policy should also include a no redirection policy. For the same reason we don't want blocking, we also don't want a consumer to type in Amazon.com and get routed to Google or Etsy or some other provider. We don't. That ought to be clear. But the idea is not to impose a duty on the broadband provider not to block, but instead impose an obligation once they voluntarily choose to serve that customer. A term and condition of that service is they have to fulfill the wishes of the consumer to go to whatever website or application they want to go to. And we think that might be a more legally sustainable no blocking policy, and also might be more practically reasonable, feasible.
Thank you.
I would be concerned
Yes.
about the minimum standard. When you're saying that, well, they can't afford it, there has to be a minimum standard they could do, or they could give them almost nothing. So I would suggest it could happen, and frankly, in my experience, I have seen things like that. And so I would tell you that businesses are in the world of making money, which is good. However, if they take advantage of people, they should not. And so if there's a minimum standard that says this is a minimum standard because it will help, but if it drops, just like this is a different, and it's something the FCC taken care of, just like when the carriers contracted with others who were supposed to serve long-distance calls, and they dropped calls or they did not even do the calls into rural areas of this country. There are a lot of ways to get around the things that we do, and if we don't have some minimum at least, and frankly, I would hope that as the network continues to be more robust and even better, that the FCC would also take the opportunity to look at what the minimum standard should be over time, because they will probably increase, which would be better for the entire country.
I just want to address, there's some policy being mixed in with the law, and that's probably inevitable. On the issue of blocking, I do think there was language in the Verizon decision that would indicate it could be banned under 706. I also think it looks very much like the roaming rule. What the automatic roaming rule said is you do have a duty to enter into roaming, but maybe not if it's proven, whatever the language was in the order, infeasible, unreasonable, I can't remember, and a bunch of factors. And so I do think blocking could be off the table. And then you may say, well, wait a second, but you just said there may be some factors. I'm not sure that the Verizon court would require that. But to mix in some policy, let me give a reason why, maybe there might be factors where blocking certain services could be okay. Oh, I know, anathema, right? But so I have talked to some WISPs who would say, video services can overwhelm our network. I also would guess there are consumers who might want to pay a lower amount for a competitive service who don't really care about getting video over it because they can get video from a satellite provider or what have you. Allowing a service to block video in order to provide, and they don't provide, let's assume in my hypothetical, they don't have their own video service, they have no ownership interest in a video service, they have no reason to discriminate, but they have decided we can better serve our consumers, disclose that we don't allow these services, better serve a certain segment of the population that wants internet, web access, sans, sort of dedicated HD video and email and access to government documents. And we can do that at a relatively low cost as long as we don't, because providing video, we're going to have to spend a lot of money to upgrade our services. Would blocking in that case be pro-consumer or not? I don't want to answer the policy question, but I think legally that's one option, is to say, if somebody actually wants to provide that service, I don't know if it'd be successful with consumers. Why should you say they can't? I think that's an example of how even the blocking, you could probably have a way to meet whatever the court's obligations would be under 706 that is an anti-consumer.
So we're running a bit short on time, and I wanted to make sure we had a few more topics to cover, but it's a testament to the discussion and how interesting it's been today. One point in particular, just real quickly, is about enforcement. So our rules can only be effective if they can be effectively enforced. And one of the things, Anne, as a state regulator, you've been in a position of where you've had to look at different kinds of rules and how they can be enforced. And I wondered if you had, examples or an opportunity to talk about that and how it might apply in this context.
State governments are different across the nation.
Sure.
None of us are the same. And if you want to talk about grain elevators, we can do about that too, because that's what we do. But in our state, we have a legislative body, which is only a one-house legislature, which makes it much easier to work with the people because it is nonpartisan, supposedly, for the most part. But they only meet once a year, and they only meet for about 4 months from January to April, or 5 months, depending on if it is an off year. So it is difficult in order to enforce rules and regulations or laws because of that timing. Right now we have another issue that's unrelated to this, that because the legislature doesn't meet every day or timely, that we can't do anything about it. So, but they can also give a commission like ours. They can say, you can make the rules and regulations, and they do that, and we have that. And so we are able to make things better quickly as opposed to waiting for the legislature to come into session.
And Ann, you're active in NARUC, obviously, the Association of Commissioners from across the land. What is NARUC's view? Would you like to take a minute to address NARUC's view as to what the state's role should be in protecting open internet?
Well, NARUC is, and I'm speaking for myself, but they are on record of saying that the states should be absolutely engaged across the nation. When the Telecom Act was first presented and started to go into effect, at that time, the chair of NARUC had to come to Washington and almost beg them to let the states be part of this. And the reason is this: we are not a one-size-fits-all nation. And so I come from Nebraska, which is very rural and very sparsely populated compared to East New York and Florida, Texas, California. Our topography is different, and so there are special problems with every territory of this country, and we need to be able to deal with those. And when they finally allowed us to come forward, I think NARUC has become much more active, and they are working with the federal government, and especially with this commission. I think that with present commission, we are happy to be that they are there, and they're willing to have an open mind, so we help them to resolve the problems that we've had. And one of them I just mentioned was the carriers who were not providing, they didn't want to pay access, and so they weren't sending calls all the way to the smaller communities in Nebraska.
So let's just take one last topic to wrap up. I have a question for Marvin and then John, if somebody else wants to come in between, but we'll give John the last word on this. And it has to do with the same topic we encountered at the end of the first panel, which was issues of free expression. Right, Marvin, you've written an article, a law review article, First Amendment Architecture is its name, that talks about the nature of First Amendment interests. As people know, there was a First Amendment challenge made to the 2010 order, but because of the way the D.C. Circuit decided the case, it never had to reach that First Amendment question. You've argued that there's an important and legitimate governmental role in providing, requiring, or permitting government to make speeches available for speech. And, of course, John, in your comments, you've identified among those spaces, among the most important kinds of those spaces, to be colleges and universities and libraries. So I wondered, Marvin, if you'd like to take a minute and talk about what you think would be the First Amendment status of open internet rules. If anybody else wants to comment on that, and then we'll finish with John talking about the fact that we've tended to discuss today consumers and end users, and you might want to bring in the kind of non-private institutions that you represent.
Great.
Marvin?
Thank you, Jonathan. I'm going to talk about blocking and then get to the First Amendment, just to respond to 2
points. You have a minute and
I'll be very quick. So Fred asked a legal question and a policy question. I think legally it would be hard to ban blocking under 706. It's not a clear-cut case, same way it is under Title II. And I think that for two reasons. The, quote, roadmap at the end of the decision isn't even dicta, right? The court said, whatever the merits of this view, and the court actually spelled out their views on 2 different points of dicta earlier in the decision. And the only judge to pass on blocking in 706 was Silberman, who said that he thought it would be per se common carriage. So I think we should have a firm ground for an anti-blocking rule. And as for rural carriers, the policy question, NTCA and others are in favor of Title II, in favor of net neutrality rules, including, Sunshine and other fiber-based carriers. So the First Amendment. So my argument is that generally the FCC and Congress have implemented rules to make spaces available for the public. And if you look at the 3.7 million comments, a lot of them talk about free expression, right? I mean, where free expression happens is the internet now. There should be a strong case for a First Amendment argument. I think that, again, Title II makes it a lot easier, right? If you look at the Turner dissent by Justice O'Connor, right, she says, and I've got the quote, "It stands to reason that if Congress may demand that telephone companies operate as common carriers, it can ask the same of cable companies. Such an approach would not suffer from the defect of preferring one speaker to another." But if you look at the Midwest Video too, there was a real concern of treating cable companies as common carriers because they were seen as broadcasters. And if you classify information service providers altogether, facilities based and not, I think the court will ask, can you impose these kinds of rules also on Twitter and Google and Tumblr and Vox? And I think you want a clear cut between the two, or else I think you're really in a place where the courts will ask, why can you impose these rules on some information service providers and not others, when there are sort of clear channels throughout the precedent about treating common carriers as non-speakers.
Anybody else want this before we finish with John? Fred?
I want to jump in the middle, and I don't know that Marvin addressed this, so maybe we do or don't agree. There is the argument out there that the First Amendment should not apply to Internet service providers. I strongly believe it needs to apply. And I've made the point, which I also strongly believe, all of the questions that Marvin alludes to can be handled by the court and by the FCC in the first instance. The First Amendment is not an absolute ban on any sort of restriction, incidentally, on speech and the like. And so I didn't want to address this specifically to net neutrality, but I do think it's important to say that the First Amendment applies, because the downside of saying it doesn't is that you would lose an awful lot of protections I don't have time to go into that I think are critically important vis-a-vis the government and its influence over the networks, not necessarily just FCC, not really FCC at all. Things that I think ISPs should be able to go to court and raise First Amendment protections in some very important instances, and the courts should be able to sort that out like they always have in the past.
Tejas, then we'll finish with John.
I just want to, maybe add to that by saying I definitely agree that ISPs ought to enjoy the full benefits of the First Amendment, so long as that is true when they're acting in their capacity as speaker. And that ISPs, when they transmit the speech of others, do not, I think, act in their capacity as speaker. And, to echo, I think, what Professor Hurwitz said earlier today, if an ISP or anybody is stepping in and interfering with the free expression of others, that is definitely a case where the FCC ought to come in and ensure that that does not continue to be the case.
John?
Thanks. So final three quick points. Education and libraries are very supportive of what the FCC is trying to accomplish here. A commercially reasonable standard doesn't encapsulate the needs of education. That's why we've proposed this Internet reasonable standard, which we think does a better job of allowing universities, colleges, libraries to take advantage of this technology in the open Internet. That applies equally to mobile. And if I could draw upon E-rate for a second, the FCC just did a great thing to encourage greater use of Wi-Fi. It would be a shame to have different open Internet rules based on whether you're wireless or wireline in a school or a library. That wouldn't make any sense. Wireless is a critical, important avenue for education and learning today. And I'd also just suggest, finally, the ombudsman. I know the FCC articulated that as an enforcement mechanism. We're very supportive of that, but the NPRM categorized the ombudsman just as promoting innovation in small businesses. We'd love it for the ombudsman to cover libraries and higher education and education in general as part of its portfolio of work. Thank you.
Thank you, everybody. We want to thank the panelists. We also want to, Stephanie and I also personally want to thank the people in the Office of General Counsel who enabled us to seem to know what we were talking about today. And they include Jim Carr, Matthew Collins, Drew Erber, Doug Klein, and Marcus Mayer. So to them, to the panelists, to everybody who participated and watched, thank you very much.